Hey, Jim.
Okay. Back in January, Mike, you when I first got my medical marijuana recommendation signed by my doctor, I posted pictures of it on Facebook, and you took those pictures. You asked my permission. I gave you permission to do it, and you posted them you wrote up a write-up about it, and you posted it on one of the newspaper columns that you write for. And everything was dated as far as when the picture was posted and when the article was written. And in the searches, in the search warrant, in the affidavit, the affiant, the police officer that was filling out the warrant, the affidavit for the warrant, puts that he exhausted all possible means of investigating whether I was a legal medical patient or not. And lo and behold, it took a 5-second search on the web for me to uncover this picture and article that you wrote, dated 2.5 months prior to when they got the search warrant. So my argument and my lawyer's argument is that he couldn't have gone to that big of an extreme to try to find out whether I was legal or not, and that could classify as a willful omission. And if it's a willful omission on the part of the affiant in the affidavit to get a search warrant, it makes the whole search warrant illegal.
Wow.
So, we are now up against the wall trying to... He realizes what has happened here. My attorney realizes what has happened, and he understands that this guy is just a rogue cop doing these things that he shouldn't be. And he's got to get what they call a Franks hearing at this point so that we can go in and prove what has been done. And it's a long shot that we can prove it, but we've got the evidence on our side. And that's where my whole case lies right now. We're going to get a Franks hearing, what they call a Franks hearing, to go in and prove that the search warrant was an illegal search warrant, that it was an illegal search and seizure, and that the cop that wrote the affidavit violated my Fourth Amendment rights.
Wow. Now let me ask you a couple other questions. When is that? When would that hearing? When would you expect that hearing to be held?
Well, we're kind of up against the wall here because of the shenanigans that the district attorney played in the beginning of the case. He kept waffling back and forth as to whether he was going to go for jail time or not. And all that did was, under federal law, Maine law, if they're going for jail time, then you are given the opportunity to have a court-appointed attorney. If there's no jail time involved, then you don't get the court-appointed attorney. And the district attorney was waffling back and forth. Yes, one day it was, yes, he's going to go for jail time. The next day it was, no, he's not going to go for jail time. I had an attorney, then I didn't have an attorney, then I had an attorney again, then I didn't have an attorney again. Well, now finally I have an attorney again, a court-appointed attorney. So they've kind of elapsed, they've kind of blown my 21-day window of getting this Franks hearing, because there is just a 21-day time limit that you're allowed to apply to get this hearing. The only thing my attorney can do is go in and argue the fact that the district attorney was waffling his position on jail time, and if that is a valid argument, he can possibly get an extension beyond the 21-day time limit on the Franks hearing request.
That's crazy.
That's the case.
So they're basically, the law in Maine only gives you 21 days to have justice, and then after that, you don't get... That doesn't make sense.
They put time limits on everything.
That's insane.
Yeah. Oh, yeah. It's very... There's United States law, there's other states' laws, and then there's Maine laws. And this is very... The versions of law that they have up here are, to say the least, draconic.
Let's ask another question. You're a legal medical marijuana user,
Yes.
and caregiver, if I'm correct, right?
Yes.
In Maine, in the state of Maine. Let me quiet my dogs down for 1 second. Just hold on 1 second, Jim.